If a will names you and someone else as co-executors, you might assume you each have equal authority to handle the estate on your own. And that's not always how it works. I've unfortunately seen this misunderstanding strain relationships and stall the entire estate process. Being named executor alongside someone else is more common than most people expect. Parents can name 2 or 3 adult children. A spouse is sometimes named alongside a professional trustee, or 2 siblings may split the responsibility equally. The intent is usually to be fair, and the reality is sometimes it can dramatically complicate things. My name is Ryan Smith. I'm a licensed realtor and certified probate expert, and I help personal representatives and families navigate probate and the estate administration process. This video covers what a co-executor authority actually means in North Carolina, how joint decisions get made, and what happens when co-executors don't agree. I'm not an attorney. What I'm sharing here is education based on my experience. It's not legal advice. However, I do highly recommend meeting with an attorney that specializes in probate and estate administration. At least have a consult in the very beginning just to make sure you're on the right track. What does it mean to be a co-executor? When a will names 2 or more executors, they're called co-executors. In North Carolina, co-executors generally must act jointly. This means most decisions about the estate, like signing documents, managing accounts, authorizing professional services, or certainly selling assets, that requires both co-executors to agree and sign off on those things. One co-executor generally cannot bind the estate alone unless the will specifically grants independent authority to do so. A co-executor who acts alone on a major estate decision without the other's involvement may create liability for both of them. The will is the starting point. If you're serving as co-executor, one of the first things to confirm with a probate attorney is exactly what authority your specific will grants, and where the 2 of you are required to act together. That process starts at the clerk of court in the county where the estate is open. So here where I am in southeastern North Carolina, that would likely be New Hanover, Brunswick, Pender, or Onslow County, depending on where your loved one lives. One more thing worth understanding early, especially if real estate is involved. If the will does not explicitly grant a power of sale, or there is no will at all, the title to real property generally vests immediately in the heirs at law upon death. That means that all heirs, and potentially their spouses, may need to sign off before any real estate can be sold, not just the co-executors. So make sure you confirm your specific authority over real estate with a probate attorney before any sale decisions are made. When can one co-executor act alone? There are situations where one co-executor can take action without the other. North Carolina law recognizes certain circumstances where a single co-executor may act independently, and that is typically when it comes to routine administrative tasks. This doesn't require a binding commitment of estate funds or the transfer of estate assets. Examples might include collecting mail, maintaining the property, or making time-sensitive decisions when the other co-executor is temporarily unavailable. For anything significant, this is selling real estate, paying creditor claims, distributing assets to heirs, signing contracts on behalf of the estate, all this requires joint action as a standard. Some wills are written to allow co-executors to act independently on all matters. Others require joint action for everything. Your specific will is what controls this, so don't assume one way or the other without confirming it first with a probate attorney. So what happens when co-executors disagree? Here's where co-executor situations most often become difficult. And if you're watching this video, you probably already know that when 2 co-executors have very different opinions about things, the whole process can get quite difficult quickly. Maybe one wants to sell the house quickly, the other wants to wait for a higher offer. Maybe one wants to hire a particular attorney, or one doesn't want to hire an attorney at all. And oftentimes, maybe the disagreement has nothing to do with the estate and everything to do with the relationship between the 2 co-executors. Regardless, when co-executors reach a genuine impasse, the clerk of court in the county where the estate is open can be petitioned to intervene. Needless to say, court proceedings are going to take time, they're going to cost money, and that money is going to come out of the estate. And if the disagreement over real estate leads to a forced sale, a court-ordered auction almost always produces less than families who resolve disagreements cooperatively and list the property on the open market. The more practical path in most cases is professional mediation or attorney-facilitated negotiation before the situation reaches a courtroom. A probate attorney can often help co-executors work through a disagreement without court involvement and in far less time. If real estate is the specific point of disagreement, a realtor who is specialized in probate can provide a professional market analysis and help both parties understand the actual options with the property without taking sides. That independent professional perspective often moves things forward when a direct conversation between co-executors has stalled. Even when co-executors agree on every decision, the mechanics of the role can add complexity. Everything takes longer. Documents that need two signatures require coordination, sometimes across distances. If one co-executor lives out of state, every signing becomes a logistical exercise. Liability is shared between the co-executors. If one co-executor makes a decision that breaches the estate's fiduciary obligations, both co-executors may bear responsibility, even if the other wasn't involved. So that's not a reason to avoid the role. It's a reason to stay involved, document all your decisions, and communicate consistently with your co-executor. What happens if there's a death or incapacitation of one of the co-executors? If a co-executor dies or becomes incapacitated before the estate is closed, the remaining co-executor may continue. But the specific rules depend on the will and North Carolina law. So confirm that with a probate attorney if the situation applies to your estate. What happens when one co-executor isn't participating? A co-executor who fails to fulfill their duties can be removed by the court upon petition. If you're finding that you're carrying the full weight of the role while a co-executor is absent or unresponsive, that's a situation a probate attorney needs to know about. Real estate deserves specific attention here. It's typically the largest asset in the estate. Decisions about it carry the most financial consequences, and it's one of the most common points of disagreement between co-executors. In most cases, selling estate real estate requires both executors to sign the listing agreement, the contract, and the closing documents. If one co-executor is reluctant to sign or simply unavailable, the process stalls. A realtor who specializes in probate understands this dynamic and can plan for it in advance. This means coordinating with both co-executors from the start, keeping both informed about the process, and making sure the timeline accounts for the additional coordination a co-executor situation requires. If you're a co-executor dealing with estate real estate in North Carolina, whether you're local to where the estate was opened, or if you're like many families I help and you're managing the estate from far away, reach out. Property assessment is free and comes with no obligation. And if the situation involves a co-executor disagreement, that's exactly the kind of situation I can help navigate. Being named co-executor is a shared responsibility. Understanding how your shared authority actually works before decisions need to be made puts both co-executors in a much better position. Thank you for watching. If you'd like to talk through your situation, or even if you just have one question you can't find the answer to, please feel free to reach out anytime to discuss the situation. No pressure or obligation for that.